In Arizona, an arrest for DUI can lead to a suspension of the driver's Arizona driver's license or privilege to drive through two possible civil license proceedings. One of those is known as an admin per se proceeding, and the second an implied consent proceeding. In this video, I will talk about the admin per se proceeding, and in another video, the implied consent proceeding. Now, an officer can commence a proceeding known as an admin per se proceeding to suspend a driver's Arizona driver's license or privilege to drive. The basis of the suspension would be the officer's belief that the driver has successfully submitted to a test, be it a blood, breath, or chemical test, and it is anticipated that the results of those tests will show an alcohol level of 0.04% or more if the driver had a commercial driver's license and was driving commercially, an alcohol level of 0.08% or more for any driver, or thirdly, for any driver that the driver had a controlled substance within their body. Now, usually the proceeding is commenced at the time of the processing for the arrest, and the way the officer will do that is they'll prepare an affidavit setting forth the reasons why they think this is going to be the case, namely that the results are going to be one of those three. The officer then takes a copy of that affidavit and serves that on the driver. When the officer does that, they take the person's Arizona driver's license, if they have one with them. If the person has an out-of-state license, then the officer can't take the license. And so what the officer will do under those circumstances, they still serve the affidavit. And similarly speaking, if the person has an Arizona license, just doesn't have it with them, or doesn't have a license at all, the officer will still serve the affidavit. After that, the officer will forward the affidavit to the motor vehicle department, who in turn will begin the formal proceeding. Now, the copy of the affidavit that the officer has given to the driver at the time of the arrest will serve as the driver's temporary driving permit for a period of 15 days, assuming that the driver is otherwise eligible to drive. If the driver's license is suspended for some other reason, they can't use this temporary permit to drive, but assuming there is no other suspensions, then the driver can drive for 15 days. The driver must, within the 15-day time period, request a hearing to contest the possible suspension of the license through this proceeding. If they fail to do that, then on the 16th day, the license suspension goes into effect automatically. Now, a second way this proceeding is begun is after the arrest is made. Sometimes the officers don't serve the affidavit at the time of the arrest. That could be because they want to wait and see what the blood results are, or they want to wait and see what the urine test results are, so they don't serve the affidavit at that time. They wait until they get the results, and then they forward the affidavit to the MVD once they do have the results. The MVD will then send the driver a notice of proposed suspension at that point, and the driver then has 20 days in which to request a hearing. Again, if they fail to do that within the 20-day time period, then the suspension automatically goes into effect. Now, if the driver has requested a hearing, either from 15 days of getting that affidavit or 20 days of receiving the notice in the mail, then the suspension of the driver's license through the admin per se proceeding is stayed. It doesn't go into effect. If the driver has that temporary permit through the affidavit, to the copy of the affidavit, that continues to act as their driver's license until a hearing is actually held. If they haven't received that affidavit because they got the notice in the mail, their driver's license still remains in effect and a valid license until a hearing is held. Now, eventually a hearing will be held before an administrative law judge at the motor vehicle department. At that hearing, the judge will decide the following issues. Number one, did the officer have a reasonable basis to believe the person was driving under the influence and therefore placed them under arrest for that? Secondly, did the person submit to blood, breath, or urine tests which indicated an alcohol level of 0.04% or more if it was a commercial driver driving commercially, 0.08% or more for any driver, or any driver and having a controlled substance within their body? And thirdly, did the police accurately test the samples that were obtained to show what the results were? If the issue is a controlled substance and the person had a prescription for that substance, That's a defense in the admin per se proceeding. It may be different in court, but in this proceeding, a prescription will be good enough as long as they have a prescription for that substance. Now, if the evidence presented at the hearing substantiates the allegations that the officers have made, then the judge will order the suspension to go into effect, usually in about 30 days. An admin per se proceeding suspension is for 90 days. Now, if a driver has no prior DUI-related suspensions, alcohol-related suspensions, within 7 years prior to the arrest on this new case, then the suspension is for 90 days, of which 30 would be no driving at all, and then 60 days on a restricted basis to and from work or school or on the job or school, or to alcohol or drug treatment and counseling. In order to get this restricted permit before the expiration of the 30 days or shortly thereafter if they wait, what the driver must do is go through a screening session for possible drug or alcohol counseling. They don't have to do any actual counseling, they just have to go through the screening session. Assume that they do that, then at the end of 30 days they would get this restricted permit. However, if the driver has an alcohol-related suspension on their driver's record within 7 years prior to the arrest on this case, the newest case, then they are not eligible for this restricted license, and so they cannot drive for the entire 90 days. It's 90 days of no driving at all. At the end of this 90-day suspension, in order to get the license fully reinstated, what the driver has to do is complete that alcohol or drug screening session, as well as pay the reinstatement fee. Once they've done those things, they get their license restored, assuming there's no other actions taken against the driver's license.